An issue that's coming up more frequently lately is whether an employee is allowed to tape record conversations with coworkers in the course of employment. The general view is that it's a distasteful thing to do and shouldn't be done, and whether it's cause for dismissal will basically depend. There is a case in British Columbia that was decided in January of 2022 in which an employee had secretly recorded discussions with coworkers. And the court determined that that was a fundamental breach of the trust relationship in employment. It went on to note that in this case there was a code of conduct that prescribed the duty of honesty. I don't know why you'd have to have a code of conduct to mandate that, but that apparently was influential. And the employee had recorded many recordings over a lengthy time period. And also he was an accountant, so he was a member of a regulated profession that added more weight to the argument made by the employer. And the court in this case said that, yes, that's cause for termination of employment. He shouldn't be making these recordings. Now, keep in mind that throughout this, that it's not a criminal act to record a conversation in Canada as long as one of the parties is aware it's being recorded. But that's a different issue in terms of whether it's allowed in an employment relationship. There is a second case in British Columbia decided in December of 2022. The company in that case did not have a policy. And again, I don't know why you need a policy saying you have to be honest. And the employee had been subject to a prior suspension, and there was some issue of a tense relationship between the parties. It was not the conversation was not taped on multiple occasions. And in that case, the court said, no, I don't think so. That's not cause for termination. So, it depends. There was a previous case decided in 2015 involving the Evans concept, that is, the employer terminates the person and then says, oh, wait a minute, come back to work. And in that case, the employee discovered the employer had surreptitiously tape recorded his conversation before he was fired. And the court said, that's good enough for the employee not to have to return to work. Now, it's a different test, a different issue, but it's some indication. There was a case in Ontario recently in which the employee tape recorded the termination meeting. And in that termination meeting, there was relevant evidence dealing with a claim the employee was making based on a promise the employer had provided to him previously. So he's reiterating the promise in the termination meeting. Now, there was no objection taken to the admissibility of the tape recording in that case. In fact, the judge asked for a copy of the tape recording to make sure that he understood the entire conversation. Not only was it admitted in evidence, again, there was no objection, but still, it was admitted into evidence, and it was used to support an award of aggravated damages, additional damages. So that was a green light on that case. Went to the Court of Appeal. The Court of Appeal upheld the trial judgment. So I think the end summary of all this is that it depends. I think most judges will think it distasteful for an employee to tape record conversations with other employees, and the employee needs to show, wait a minute, this is an exceptional situation. This is my narrative now. The employee needs to show some motivation, exceptional reason for tape recording the conversation. I know when I was in practice, I didn't like to use tape recordings. I thought, generally speaking, people are going to be annoyed with it, and there has to be a big bang for the buck to make it worthy of introducing the tape recorded conversation. So, generally speaking, it depends. That's the end result of the tape recording issue.